Hello, everyone, and welcome to another Health Reform Beyond the Basics webinar. Thank you so much for joining us today. For those of you who are new to our webinar series, this is a project of the Center on Budget and Policy Priorities, which is a nonprofit policy think tank in Washington, D.C. This series is designed to help advocates, assisters, state and local officials, and others assist people to access and understand the Affordable Care Act's health coverage options. It is intended for those working on the implementation of health reform, and it is not intended for press purposes. Today's webinar will provide information on marketplace appeals. It will detail what decisions can be appealed, how to file an appeal, and ways to expedite the appeal process. We are very pleased to be presenting this webinar with Mara Udelman from the National Health Law Program. Mara is the managing attorney of the National Health Law Program's Washington, D.C. office. She has been with NHeLP for over 15 years and focuses on issues including Medicaid, health disparities, and implementation of the Affordable Care Act. Now, to guide us through today's topic, please welcome Mara Udelman.
Good afternoon, everyone, and I'd like to thank the Center on Budget and Policy Priorities for inviting me to come and speak with all of you today. So we're going to walk through the marketplace appeals process. First, I'll give you a brief overview of the National Health Law Program. If you're not familiar with NHeLP, we were founded nearly 50 years ago, and we're a national nonprofit organization that focuses on access and quality of health care for low-income and underserved populations. We do a lot of our work on the Medicaid program, and since the ACA was enacted, also on ACA implementation as well. Please feel free to take a look at our website. And also on the Beyond the Basics website is an appeals fact sheet that we put together that outlines a lot of the information that I'll cover in the first half of this presentation. So you can also get that fact sheet and see that summary. I do just want to provide a brief disclaimer. While I am an attorney, this presentation today is for informational purposes only, and neither NHeLP nor the Center on Budget is providing any direct legal advice. So please make sure you're using this for informational purposes only. So as Hallie mentioned, the agenda, we're going to go through 4 primary topics. We're going to talk about when an eligibility decision can be appealed, the role of assisters in appeals, the process for filing appeals, and then how appeals decisions are carried out. For the most part, we're going to be talking about the process that appeals in the federally facilitated marketplace, or the FFM, for those consumers who are applying through healthcare.gov or using paper applications to apply to the FFM. Some of this will also be applicable to state-based marketplaces, but primarily consumers and assisters in state-based marketplace states should become familiar with the processes that apply to that state. Once final decisions are obtained from a state-based marketplace, those are appealable up to the federal appeals entity at the federal level, but consumers must first go through the basic processes of filing an appeal and attempting to get a resolution in a state-based marketplace. So again, most of what we'll be talking about today is the Department of Health and Human Services Federal Appeals Entity, or FAE for short. In terms of organizational structure, and I think this is actually useful to know, the FAE is not part of the same part of CMS that administers the marketplace. So many of you are familiar with CSIO, the Center for Consumer Information and Insurance Oversight. The appeals entity actually resides outside of CSIO when consumers are filing appeals because they have concerns about their eligibility decisions or other issues related to eligibility. They're actually getting a fresh look by different staff who run the appeals entity as opposed to healthcare.gov and the call center. So the first topic that we're going to talk about today is what determinations can be appealed. It's important to understand the scope of what can and cannot be appealed so that we don't take consumers and advise them to file appeals when they actually it's not going to be a useful process, and it could actually just delay getting themselves assistance and also delay others getting assistance if appeals are filed that really shouldn't go through the appeals process but might be able to be assisted through other channels. And this is an area where actually the fact sheet does go into detail, so I'd encourage folks to take a look at that on the website. So not all issues can be appealed to the federal appeals entity. The first and probably the most important facet to recognize is that a determination must be final. Any interim or temporary eligibility determinations are not appealable until they become final. So, and we'll talk through this and give an example a little bit later, but if a consumer, for example, has a data matching issue or inconsistency and has to provide additional documentation about their income or their citizenship or immigration status, they may get a temporary eligibility determination, and they can't appeal that until they've provided their documentation or not provided their documentation and gotten a final determination. There are a couple other types of issues that are not appealable to the federal appeals entity but can be addressed in other ways. This includes casework, which often happens after an escalation if the call center at healthcare.gov is unable to assist a consumer. There also are avenues to appeal directly with an insurer, and some issues should be addressed through the State Department of Insurance rather than through the marketplace appeals entity. So let's walk through sort of the four big categories that we have of issues that consumers may face and what are the appropriate remedies for each of these and where consumers should first look. Casework is a function that happens within the federally facilitated marketplace. Excuse me. It's appropriate if the consumer is sort of running into a problem with the call center and the issuer can't actually help related to eligibility or coverage. This also sometimes happens if a consumer might be eligible for a special enrollment period based on exceptional circumstances if the call center is unable to grant that. Or, for example, if a consumer receives a 1095-A detailing the months that the consumer had coverage during a year and the premiums that were paid, and the consumer believes that there are errors. In each of these situations, the consumer or an assister should ask the call center to submit a case to casework. Now, one thing to recognize is that a consumer actually could have a case going through casework and file an appeal at the same time, but for the most part, a consumer is going to be able to get a quicker resolution and often an easier resolution if something can be addressed through casework rather than having to start a whole new process by filing an appeal. So in casework, a person not at the call center, but in usually a CMS regional office is looking at a fresh look at what the consumer is outlining or the problem. This is usually available if the call center is unable to assist or unable to answer an eligibility question. And in the slide deck here, we've provided a link to a webinar that CMS put out for assisters back in 2015 that provides a more detailed overview of the casework process. Right now, at the time of year where consumers have been getting their 1095As from the marketplace, this is where we actually usually see an uptick in requests for casework if consumers believe that information on their 1095A is incorrect and the call center is unable to provide a revised version that sufficiently addresses the consumer's concerns. So that's a specific area right now in terms of timing and right around tax season where casework really does come into play. The second bucket that we'll talk about is insurer appeals. There are a number of situations where the federal appeals entity is not going to be the right entity to address an issue, and consumers should actually be looking directly at getting assistance from their insurer. So some of these situations might include a provider who the consumer thought was in network but may have left the network or was erroneously included in a provider directory. If a consumer attempted to receive services, for example, at an emergency room and gets a bill that was out of network and payment is owed. If an insurer denies a claim for a service or procedure, including a prescription, or if an insurer canceled coverage. In each of these situations, the consumer should first be looking at what internal processes the insurer has to resolve complaints or grievances or appeals. Those are all different terms that insurers may use, but there usually is an internal process that a consumer can file and request to have a decision reevaluated, to have a procedure approved even if it was denied initially, or to address issues with out-of-network providers. So in each of these cases, the consumer should look for an internal appeal with the insurer, And if the resolution of the internal appeal is not acceptable to the consumer, there's usually also an option to file an external appeal. Again, these are state-based processes with the insurer and sometimes with the Department of Insurance, and the consumer would not go through the federal appeals entity. Otherwise, they just get a denial from the federal appeals entity as not having jurisdiction over that. The third bucket out of the four are issues that the consumer should address directly to their own state Department of Insurance, again, rather than going to the marketplace appeals entity. Again, there are a number of these situations that sort of mirror what may have happened at the insurer level. And when a consumer doesn't get relief from their insurer, they may want to turn directly to the Department of Insurance. So for example, this could be if the insurer denies coverage of a claim or a service, the consumer goes through the insurer's internal appeals process, gets a confirmation of that denial, then the consumer might want to go to their state Department of Insurance. Also, if the insurance terminates coverage, provider directory issues, denying of claims that may violate mental health parity or other discrimination laws, or if there was fraud in the selling or use of insurance. In these cases, again, the consumer's best bet is to go directly to the Department of Insurance, which regulates insurance carriers in each state, rather than come to the marketplace, because while the marketplace does approve and certify the insurers who participate in the marketplace, the sort of day-to-day or week-to-week activities of the insurer are really overseen in the states by the Department of Insurance. So now that we've provided sort of the three big buckets when consumers should not go to the federal appeals entity, let's actually switch and talk about what types of claims a consumer can bring into the federally facilitated marketplace or the state-based marketplace. These are really directly related to the eligibility determinations that are made by healthcare.gov or a state-based marketplace. So these kinds of decisions include denial of APTCs or cost-sharing reductions. If the consumer gets an amount of APTCs or cost-sharing reductions that the consumer thinks is wrong, it might be too little, it might be too much. If APTCs or CSRs are adjusted at the end of an inconsistency period, denial of eligibility to enroll in coverage, denial of a special enrollment period, termination of coverage, denial of an exemption, and denial of eligibility for Medicaid and CHIP. As you can see, all of these are really tied to the decision that healthcare.gov or a state-based marketplace is doing when a consumer applies for coverage. It's not addressing the use of that coverage, but it's related directly to the eligibility for coverage, the amount of coverage that's provided, or the termination of coverage. In these situations, consumers should be looking at filing an appeal generally within 90 days of a final eligibility determination. And there is information on healthcare.gov that explains more in detail about what can be appealed. And also state-based marketplaces should have this on their website as well. So just to reiterate, as we mentioned at the beginning, consumers in state-based marketplaces can appeal these same issues to their state-based marketplace, and they should use that as their first avenue rather than appealing to the federally facilitated marketplace. Once a consumer receives their decision from their state-based marketplace, if they disagree with it, then they can actually appeal up to the federal appeals entity as long as it's addressing marketplace eligibility. If the consumer has issues with a state-based marketplace decision about Medicaid or CHIP eligibility, that's going to have to go through the Medicaid and the CHIP appeals process rather than coming up to the federal appeals entity. And just to reiterate a couple of other things, and then we'll get into some specific examples. As I said before, an eligibility determination must be final before it can be appealed. So if a consumer has any inconsistencies and is supposed to be providing additional documentation to the marketplace, that temporary eligibility determination, even if the consumer has coverage and even if the consumer is getting tax credits, that decision cannot be appealed until it is final. Okay, so let's go into a couple of examples. This first one here, we have Susan who applied for coverage, and she's determined eligible for marketplace coverage with APTCs, and her daughter is determined eligible for Medicaid. So her daughter Alana is going to be sent for Medicaid for a final determination. What can Jane appeal? Well, Jane was determined eligible for marketplace coverage, and since we all know that if you get Medicaid or CHIP, you can't get marketplace coverage, effectively her eligibility determination saying she's eligible for APTCs means she's ineligible for Medicaid. So if she thinks that's a wrong determination and she actually should be eligible for Medicaid, she can apply that decision. Maybe, for example, she's pregnant and she thinks that because of her income and her household consistency, she should have been in Medicaid instead of the marketplace. That would be something that she could actually appeal. She also could appeal the amount of tax credits that she received. So if she thinks that based on her knowledge or talking with an assister that she should have received maybe more tax credits than she got, that's something else she can appeal. She can't appeal the assessment that Alana is eligible for Medicaid until that determination is final. So she's going to have to wait until the state Medicaid agency sends her information about whether Alana is or is not eligible for Medicaid. And at that point, she can appeal that decision. So let's go through another example, which would be one of these temporary eligibility determinations. In this case, we have John who applied to the FFM and received an eligibility determination that says he's eligible for APTCs but not CSRs. It also says his decision is temporary and he has to provide proof of his citizenship status. Can he appeal that he isn't eligible for cost sharing reductions? No, not yet. Until he provides his citizenship documentation and a final eligibility determination is made, he cannot appeal that he did not receive CSRs, even though that's not one of the issues that's related to temporary. So his citizenship is sort of the inconsistency that he has, but until that is resolved one way or the other, he can't appeal some of the other decisions that are made in his eligibility notice. So at this point, before we go into how to request an appeal, we're going to see if there's any questions on what I've covered so far, and then we'll go into the second half of the presentation, which we're going to outline a little bit more about requesting an appeal, how appeals are considered by the marketplace, and how resolutions are addressed.
So you can type questions into the question tab on your GoToWebinar toolbar. So one question we got is, what action will or does the Department of Insurance take when you file a complaint to them?
Sure, and this is going to depend a lot on each state's Department of Insurance, and some state Department of Insurance are more proactive in response to consumer complaints. Some have set up specific offices to respond to these. But in general, the Department of Insurance is going to investigate a complaint that it receives and likely is going to contact the insurer to determine an appropriate resolution. So first, the Department of Insurance, before it acts, is going to want to make sure that any claim brought by the consumer is a valid complaint. And then it will look into what the appropriate solutions might be. So a lot of this is dependent on your state and how they've set it up and what their jurisdiction is.
And then let's see, in the example that you just had with Susan and how Susan could appeal, but her daughter could not, could you just go over why that is again?
Sure. So let me go back to that slide. In this case, Susan has been determined eligible for marketplace coverage with subsidies. That's a final determination. Alana is assessed eligible for Medicaid, but the final Medicaid determination is likely going to be made by her state Medicaid agency. So it might be that they need a little bit more information, or they're going to just check on her application and see what's happening. So in that situation, Alana sort of has a temporary Medicaid eligibility determination, but it needs to be finalized. Once it's finalized, whether she's determined eligible or ineligible, that can be appealed. But at this point, when she's just assessed eligible, and again, it depends on states whether the FFM is making your Medicaid determination or transferring it to the state to make it. So that's really where it comes into play in terms of the state usually is making the final determination, and until that Medicaid determination is made, they're going to have to wait.
And then is termination due to non-payment of premiums appealable?
That's a good question. I mean, technically it could be, but the reality is, since termination due to non-payment of premiums is not going to allow a consumer to re-enroll in coverage because of the way the rules are, the appeal is probably really going to be a futile issue. If there's a reason that the consumer did not pay, perhaps the consumer was hospitalized or incapacitated, in that case, the consumer could think about appealing and sort of trying to make the case that it was beyond the consumer's control as to why the payment didn't happen. But in general, if the consumer has sort of affirmatively chosen not to pay and coverage is terminated, that consumer really is not going to have any legal rights to get coverage reinstated.
And then we're going to do one more question now, and then we'll do more questions at the end of the presentation. So in a FFM state, so a state that uses healthcare.gov, when does a Medicaid appeal go to the state, and when does it go to the federal entity?
Sure. In general, the Medicaid appeals are all going to go through the state Medicaid agency. So if the state approves it or the state Medicaid agency denies it, your best bet is really going to be to work through the Medicaid agency. If Medicaid is denied, and then the consumer sort of transferred back to the marketplace and gets APTCs or CSRs and disagrees with the amount of the APTCs or another facet of the marketplace eligibility, then that consumer could apply to the federal appeals entity and go through the marketplace process. But in general, the Medicaid and CHIP appeals are separate from marketplace appeals, and that stays in the state with the state Medicaid agencies.
Perfect. And then we will continue on, and we'll take more questions at the end.
Great. So let's start going through how to request an appeal. There are a couple of different ways to request an appeal. The best option is to actually complete an appeals request form. We provide the link on this slide here, and actually very recently CMS has released sort of a fillable PDF. So this link will get you to a form. You can open a PDF, you can type directly into that PDF form, and then you can print it out and either mail it or fax it. At this point, you cannot file an appeal by phone, and you cannot file an appeal by email. So you have to take this form and fill it out and then mail it or fax it. You also can write a letter explaining the reason for the appeal, but given that the marketplace is sort of used to the form that it's created, it actually is more helpful, I think, if people try to fill out that form. They can send in supplemental information. They can add a letter as well. It's also especially important to add a letter if the consumer has special circumstances that might not be adequately described in the form. So for example, if the consumer may have a disability and need an accommodation and wants to provide additional supplemental material, that might be something to include in a letter or other materials. If a consumer is appealing after the sort of 90-day cutoff period, the consumer, again, may also want to provide additional information as to why they missed the 90 days. Again, maybe they were incapacitated, maybe they didn't realize when the 90 days started, something like that. So let's talk a little bit about timeframes for requesting an appeal. In general, it must be done within 90 days of the contested eligibility determination. So for example, consumers pretty much who applied during open enrollment this past year, if they applied towards the end of open enrollment, let's say, towards the end of December, that 90 days is going to start ticking from whenever that eligibility determination was finalized. So for some consumers, their time is going to be up pretty quickly in the next month or so of that initial 90 days. Again, consumers with temporary eligibility notifications, that 90 days won't start until the eligibility determination is final. So if a consumer applied during this past open enrollment, had an income inconsistency that was resolved, maybe let's say March 1, disagrees with that eligibility determination, they'll actually have 90 days from March 1, not from the date of their original application. If an appeal is dismissed, either because the appeals entity decides that the consumer didn't have grounds, didn't have the right information, or wasn't appealing something that could be appealed to the FFM, the consumer has 30 days to request that it be reopened and can provide additional information. In state-based marketplaces, once the state-based marketplace decision is finalized, consumers can then appeal to the federal appeals entity within 30 days of the appeals decision, or 30 days after the state-based marketplace declines to reopen the appeal if the consumer had requested that. Again, this 90 days is pretty hard and fast, but if a consumer has a valid reason as to why they could not appeal within these 90 days, it's worth including that information. It's sort of a good cause exemption, and the consumer should include that information when they submit the appeal. Once an appeal is received by the marketplace is going to go through a couple of steps to determine what the next process will be. So first, it's going to evaluate if the appeal is valid. And again, this goes back to those slides we did at the beginning of what should be appealed to the federal appeals entity versus the insurer versus going through casework versus going to the Department of Insurance. So if a consumer states a valid reason that the federal appeals entity has jurisdiction over, then the appeal will be acknowledged in writing and the appeals process begin. Let's say the consumer appeals something about a denial of a service from the insurer. That's the kind of case where the appeals entity is going to say, actually, this appeal is invalid. You can't come to us. You're going to have to go through your insurer, and they're going to deny the appeals request. So again, it could happen for a number of reasons why an appeal is determined invalid. It could be more than 90 days. It could be a temporary decision, or it could be one of these cases where the federal appeals entity does not have authority. So one of the questions that we get an awful lot, and I think has been proven very confusing for a lot of people, is who can assist in an appeal and what does assistance mean? Many of you are probably familiar with the term authorized representative. And part of the problem that we've seen is we use that term in a couple of different situations that can get confusing. An authorized representative can mean different things at different stages of the eligibility process. So someone who helps a consumer call the call center and apply over the phone or troubleshoot with an application, that's someone who's usually called a third-party representative. That person really is helping a consumer and not making decisions on behalf of a consumer. That's usually where assisters and navigators and certified application counselors are going to fall into that category. Sometimes you do have a consumer who's unable to act on behalf of themselves. Either they're a minor or they might be incapacitated and have a legal guardian. In these cases, to assist with an application, a consumer may actually have an authorized representative. In terms of the application process, an authorized representative can actually make decisions on behalf of the consumer. So they could file an application for a consumer. They can decide about whether they want to apply for financial assistance or not. In the appeals context, the authorized representative has a different role, and it's actually a legal representative. So when you start, excuse me, when you get to the appeals process, there really is a distinction, and someone needs to know if they're an authorized representative for the application or the appeal. In the appeals process, it really is a lawyer who should be an authorized representative. An assister or a navigator can certainly help a consumer in the appeals process, can actually serve as a witness, can help present information, but likely should not be acting as an authorized representative because the legal rights of the consumer are actually at stake here. So let's dig a little bit deeper about the role of navigators or assisters in the appeals process. In the majority of appeals, the applicant actually will represent herself without legal assistance. But as I said, assisters can really help consumers understand whether they have the right to appeal, help them find that information on healthcare.gov, including appeals forms and the grounds for an appeal. They can help access information such as the request form, maybe the eligibility notice that the consumer wants to submit as well. They can help consumers meet the deadlines for appealing, and they also can refer to consumers on where they can go to get legal help in their area. What navigators and assisters should not do in the appeals process is provide legal advice. So they shouldn't actually recommend that consumers take action, whether to appeal or not to appeal. They can help explain the differences and explain their rights, but they shouldn't actually advise the consumer what the consumer should do. And navigators actually do not have a duty to represent consumers as an authorized representative, sign an appeal, or file an appeal on the consumer's behalf. In fact, for navigators who are specifically funded by the federally facilitated marketplace, they actually cannot use federal funds to serve as an authorized representative. So unless that entity has separate funding to allow them to serve as an authorized representative, navigators are often prohibited from actually serving in that role. So let's go through a couple of examples about authorized representatives and what the roles of assisters can be. In this first case, we have Ashley, who is unable to resolve an application issue through casework and is looking at appealing. David helps her file her appeal and followed up with the appeals entity to make sure it was received and processed. And her informal hearing, which will happen over the phone, is happening in a few weeks. So can David participate in the hearing on Ashley's behalf? Only in a limited way. He can participate as a witness. He can help explain information and how he may have helped Ashley during the application process, but he should not act as her authorized representative. So he should not be the one sort of presenting information initially. He shouldn't be the one sort of questioning Ashley. He really needs to serve as sort of a secondary role. In addition, because Ashley's legal rights are at stake, she may actually want to see if she can get a legal representative to assist with her appeal. And we've included a link here to a website. Many low-income consumers are eligible for free legal assistance through their local legal aid or legal services organization. And there's a link here that gets to a directory that consumers can get help. So now we're going to go through a little bit about the appeals process and how eligibility and appeals decisions are actually implemented once final decisions are made. So the first stage of an appeal is actually going through informal resolution. This is done again over the phone. It's an informal process where someone from the appeals entity is going to call the consumer, review the facts and information, gather more information from the consumer. At the end of the phone call and after examining all of the information, the appeals entity is going to propose a resolution. If the consumer is satisfied, great, everything is done, the decision will follow, or the consumer may voluntarily withdraw the appeal. It might be that the consumer actually learns during this process that they didn't have appropriate grounds to file an appeal. If the consumer is unsatisfied with the result of this informal resolution, then the consumer may request a formal hearing, and we go on to the second phase of the appeals process. The second stage includes a formal resolution or hearing, and this happens with someone at CMS in the Marketplace Appeals Group, and it's actually a hearing officer. They're not all lawyers, but they are trained hearing officers, and they're specifically trained to address Marketplace appeals. This is also a telephone conversation. And what happens is there will be sort of what we call a de novo review or a brand new review by the federal appeals entity. Again, consumers can present witnesses and evidence. They also can have an authorized representative. Everything is done under oath, so it's very important that both consumers and anyone serving as a witness understands the legal ramifications of that. There also is an opportunity for consumers to request expedited appeals, which means these happen on a quicker time frame. The only time that a consumer can request expedited is if the standard time frame would jeopardize the appellant's life, health, or ability to attain, maintain, or regain maximum function. This needs to be noted on the initial appeals request, or if something happens after the initial appeal is filed that makes an expedited request needed, they can update their application and request an expedited process at that point. If the request is denied, then the appeals entity must provide written notice and consider the appeal under the standard deadlines. So let's go through an example of this. If Diane wants to appeal her eligibility determination, she is going to be paying 100% of the premiums while the appeal is going forward. As we said, it can take 90 days. It actually can take a bit longer than that. If paying 100% of the premiums because she was denied APTCs is a financial hardship for Diane, can she get an expedited appeal? No, the answer, unfortunately, is that she can't, because you can only get an expedited appeal if it jeopardizes the appellant's life, health, or ability to attain, maintain, or regain maximum function. So a financial hardship alone is not going to be grounds for her to get an expedited appeal. In this case, if she has a chronic condition and needs monthly medication that she's unable to get because she doesn't have coverage in the interim, Can she request an expedited appeal in this case? The answer is yes, because her health may be at risk. So a financial hardship alone will not get you an expedited appeal, but something that's affecting the consumer's health or life or safety could. After an appeal hearing happens, the hearing officer will make a decision based on the testimony and the evidence and will issue a decision in writing. It should happen within 90 days. Unfortunately, many appeals are actually taking longer than that, and the regulations say within 90 days or as soon as administratively feasible. Again, we've tried to assist consumers who sometimes get stuck in this if they're having problems, but this is something that an assister could help a consumer by following up with the appeals entity and trying to get updates and find out what's happening with the case. Once an eligibility decision is made by the appeals division, it has to be implemented. Now, if you remember a little bit a ways back, I explained how the appeals division is separate from healthcare.gov and CSIO. This means that the appeals decision actually has to be transmitted back to the marketplace and then implemented. Sometimes this can be challenging and take some time. So again, follow-up and persistence is really important. Consumers have two options for implementing a favorable appeals decision. They can have it done prospectively, meaning going from the date of the decision forward, or they can have it done retroactively, which actually would take the decision all the way back to the date that the consumer applied for eligibility. So let's take a look at retroactive coverage first. We have an example here where May was denied APTCs that would have started on January 1st, 2007. She appealed and the decision was favorable to her. If it's now June, can she actually get her APTCs back to January? And the answer is yes. So she could go back to January 1st, or she could also start on June 1st on the date of her appeals decision was made. If she wasn't getting coverage during the appeals process, she can ask for retroactive coverage. The issue here is then she would actually have to pay her share of the premiums for each of those retroactive months. So if she applied in January, her appeal was finalized in June, she had 6 months without coverage, she can ask for the decision to be made retroactively back to January, but then she's going to have to pay her share of costs from January to June. And that could be a financial hardship for some individuals. So it's really a consumer by consumer decision about whether to go retroactive or not. Consumers can't sort of pick an interim date. She couldn't say, well, actually, I didn't have any healthcare costs in January, February, March. I did have some in April. Can we go retroactive to April? It's sort of all or nothing. She's got to go back to the original date of coverage in January or go prospectively starting in June and going forward. So again, it depends often on the consumer situation, whether they had incurred any expenses that it makes sense to go retroactive, or it might make sense, or they would suffer paying the penalty, or it makes sense to just go forward. We'll do another example here, and then we'll wrap up and have time for some questions. Here's an example of the family glitch. Benita's husband has affordable insurance through work, but the cost to insure Benita is too expensive, so she's in the family glitch, which means she's ineligible to get APTCs on the marketplace because of how coverage was defined. So she applies to the marketplace, she's denied APTCs. Can she appeal? Well, yes, she can appeal because she had an appropriate denial. Is she going to succeed in her appeal? Actually, no. So this might be a case where education by an assister would actually be helpful, that while technically she has grounds for appeal, the result of the appeal is going to be the same. Because she's in the family glitch, she's ineligible to get APTCs. There are a couple of places that consumers can get help filing their appeals or getting information. The first is the General Marketplace Call Center. This is both at the FFM and state-based marketplaces, can provide information. There's also information available on the websites. Once a consumer actually files an appeal, they can actually call about their specific appeal and get information from the Marketplace Appeals Center. The Appeals Center is not going to give general information, but once a consumer applies and gets accepted or denied, then they can ask questions about their specific appeal. And then again, we've included this website to get authorized representatives for free legal assistance. So just wrapping up, a couple of key points to remember. When a consumer wants to appeal, they can write a letter, complete an appeal request form, fill out that fillable PDF, but they do have to mail or fax it in. They cannot do it over the phone, and they cannot do it by email. The first step is the Marketplace Appeals Center is going to try to resolve eligibility informally with a telephone conversation. If a consumer is dissatisfied, they can request a formal hearing with a hearing officer. And then decisions are usually mailed within 90 days of receipt or as administratively feasible. We've included a couple of websites here, including the link to the fact sheet I mentioned at the very beginning, and some links on healthcare.gov where you can find more information about what can be appealed in the Marketplace Appeals form. So at this point, I'm just gonna, are we gonna do questions and answers?
Yeah, we're gonna do questions and answers. Feel free to type in your questions right now, but before that, we're actually gonna have a little, a quick little unveiling of a new tax tool that we have. And for that, we're going to pass the presentation to Tara Straw, who is a senior policy analyst here at the center. She's going to walk us through this new interactive tax tool that we created. So take it away, Tara.
Hi, I just wanted to give you a little introduction to this tool. It's been on our website for a couple of months now, but it helps you determine eligibility for some of the more complicated exemptions that are based on income. I know that some of you get a lot of questions around this time of the year from people who are seeking exemptions, and maybe they didn't understand what their tax preparer was talking about or felt like their tax preparer had done something wrong. And so we put together this tool to handle some of the most common ACA exemptions. Income below the filing threshold, income below 138% of FPL in non-expansion states, unaffordable coverage at work, and unaffordable coverage in the marketplace. These exemptions are complicated because they all have these different income thresholds that are based on size of family or filing status. They use different calculations of income, and they have a lot of special rules and challenges. So here's a look at the tool. You would start by just entering in some very basic information about the state you're in, the client's tax filing status, the number of people in the household, and the income. And then we just walk through the exemptions one by one. So first we start with income below the filing threshold, which most tax software will do automatically. Then for, if you indicated that the person is in a state where, is in a state that didn't expand Medicaid, then this second piece will pop up, testing for that particular exemption. If you're in a state that where this doesn't apply, then that section won't appear for you. And then it goes into the test for the affordability exemption. First, starting with whether or not someone has affordable employer-sponsored coverage, and then going through the test about whether someone had affordable marketplace coverage. Now, there are a lot of bells and whistles related to how you calculate this exemption, you know, where you find the lowest cost bronze plan, where you find the second lowest cost silver plan, and lots of rules about who you include among the family members in each of those amounts. And so we've spelled out as much as possible how to apply the rules, including putting the Medicaid eligibility levels for kids and for adults on the screen. So right now, tax preparers have a big challenge because they're supposed to exclude people who are eligible for Medicaid, but they don't know who's eligible for Medicaid. So we've integrated that. Now, in general, this tool is going to be most useful for people who are tax preparers, maybe people even preparing their own taxes. But again, you know, we thought that, you know, many of you get questions about exemptions. We know because many of you ask us questions about exemptions. So we're hoping that this tool will help people figure out some of these more complex things.
Perfect. Thank you. And now we'll take some questions, and we probably won't get to everyone's questions. So if we don't get to your question, feel free to email us. Just email that beyondthebasics@cbpp.org email box, and then we'll get your question answered. But we'll try and answer as many as we can right now. So let's see. First of all, with the authorized representative, can a non-attorney advocate from either a nonprofit or a for-profit organization act as an authorized representative?
I'm going to assume the question is, can they act as an authorized representative for the appeal? And the answer is yes. But again, I want to caveat that, and maybe this is because I am an attorney, but we are talking about an appeal that the consumer's legal rights are at issue. And so, it's one thing to have an eligibility determination, but when you're going through the appeals process and the consumer is having an informal hearing and then possibly a formal hearing with the hearing officer, the legal rights of the consumer are at stake, and there often are legal questions that may come into play. And so having someone who has that legal training in terms of being able to research, are there any prior cases, but more importantly, what does the statute say? What do the regulations say? Those are all really important aspects that really can sometimes make or break a decision for a consumer. And for many consumers, there's huge financial repercussions of this, whether they're getting enough APTCs in order to maintain their coverage, whether they were denied coverage, whether they have to repay coverage at the end of the year because they got too much APTCs going through the year. So some of it is also whether you actually want the responsibility of serving as that authorized representative, as opposed to potentially being a support or a witness for a consumer as opposed to an authorized representative. So again, I think if you've been helping a consumer, you certainly can participate in a hearing as a witness and help explain all of the steps that you may have taken to get the consumer the right information or to provide the right information to the marketplace without actually taking on the formal role of an authorized representative. So it really is just sort of that word of caution that there are legal issues that can come into play in these appeals. And so knowing sort of the limits and the boundaries of what you may provide, making sure a consumer understands that if you are stepping into the role of the authorized representative, so the consumer doesn't later say, oh, I didn't really understand this, and I should have gone and gotten a lawyer, and that gets you into other trouble. So really educating the consumer, understanding that the consumer has the right to try to get legal representation is probably your best bet, and then to serve as a role more as an advocate or a witness as opposed to the authorized representative might be your best bet.
And then can a navigator, an official navigator, help fill out or complete the appeals form with or for a consumer and fax it for them?
I certainly think you can fax it for them. I think you could assist a consumer in filling it out, but you really do want to make sure that the consumer is providing all of the information that's needed in that form, and that you really are just serving as a conduit as opposed to someone who's inserting their own values or their own opinions or their own information in. Again, I think as an assister, you could provide a letter that supplants or supplements the appeals form from a consumer. You can certainly help a consumer fill it out. You can ask the questions for the consumer. You could help type it if the consumer wants to dictate it. But I do think you have to be careful of not actually filing it sort of instead of the consumer, and that this really is done with all of the information the consumer provides you.
And then someone asked the appeals fact sheet that we mentioned that you guys put together for us. Is that aimed towards assisters only, or is it appropriate to share it with consumers as a helpful tool?
You certainly can share it with consumers. You certainly could share the recording of this PowerPoint or the PowerPoint slides with consumers. That's all appropriate. What the fact sheet does is sort of tries to distinguish those 4 buckets we talked about at the beginning, and actually it includes those same sort of boxes or charts that we saw in the earlier slides about, when to go to casework, when to go to an insurer, when to go to the Department of Insurance, and when to go to an appeal. So certainly all of that is accessible for consumers. As an assister or navigator, you might just have more experience having helped a number of consumers with this, but certainly please feel free to share it.
And then can an appeal be written in Spanish? Is that appropriate? Can they do that?
It should be appropriate, and it should be accepted by the federal appeals entity, and then they should be working to have it translated and to address it. Again, that's our understanding of the availability of language services, both the translation of forms provided in other languages, as well as having interpreting services available on a call. And so again, if a consumer is going to need, for example, an interpreter when they have the informal or formal hearing, that probably should be requested in advance because it's easier to plan and have that in place. And again, I would suggest that an assister not serve as an interpreter unless that assister actually is trained and recognized and has the competency to serve as an interpreter, but certainly could help make sure that the request is made so that the consumer does have a competent interpreter available during the hearing.
And then you went over this a little bit in the webinar, but what is the federal entity's timeline to address an informal appeal, and what is the expedited appeal response time from the FAE?
Sure. In general, what the regulations say is that an appeal from start to finish should happen within about 90 days, or, and I quote this from the regulations, as administratively feasible. So unfortunately, what we've seen is that many of them are not actually finished in 90 days. I think, again, it depends on how complex it is. Some of it depends on the time of year. If there's, a greater filing, a number of appeals filed within a certain period of time. The expedited appeal is supposed to happen more quickly. I don't recall actually if there are actual timelines in the regulations. If you shoot me an email, I'll take a look at that, or shoot the email to Beyond the Basics, and we'll take a look at that. But I think this is one of the challenges. They're working as hard as they can. The informal hearing, again, is going to happen more quickly. If a consumer is not satisfied with the informal hearing, getting a formal hearing does take longer, and since there are just a few hearing officers, that also can sometimes mean a resolution is longer to get as well.
And we'll take just a couple more questions. Someone has seen a lot of people whose plans were terminated for non-payment at the end of a grace period, but they didn't receive proper notice about the non-payment, and they didn't receive proper notice about the grace period in general. Would this be something that can be appealed, or no?
These are probably issues that someone should be actually looking and talking with their insurer and their State Department of Insurance about, at least initially, because the payment of the premiums is going directly to the insurer. So any questions about whether payment was received, whether there was an automatic withdrawal, whether the appropriate amounts were done, first you're going to have to actually gather some paperwork from the insurer to try to track it and understand it. And then again, if improper notice was not sent by the insurer about the termination, that's something the Department of Insurance is likely going to have jurisdiction over.
And then for our example with May, let's say she doesn't, and she had the option to do retroactive coverage. She wanted an appeal. She could do retroactive coverage or have it be prospective starting in June. If she doesn't ask for the retroactive coverage, will she be penalized for having a failure to have coverage from June to May?
Yes, if she is without coverage for more than 3 months, then she would be subject to paying the individual responsibility payment for not having coverage. She could, I don't think she might be able to request like a hardship exemption from paying it because she had an appeal going forward, or depending on where her income was. So there might be other avenues there, but I think in general, yes, if you're without coverage for more than 3 months, you generally are subject to paying that penalty.
And we can kind of look into that too and try to follow up directly. So with that, we're going to bring this to a close. Again, if you have any questions, if your question didn't get answered, if you have a follow-up question, please email our Beyond the Basics contact email at beyondthebasics@cbpp.org. It's on your screen right now. And we'll try to get those questions answered as quickly as we can. And then lastly, just a huge thank you to Mara for coming and presenting for us. We really, really appreciate it. And thank you all for joining us. So we'll bring this to a close. Thank you.